Proving a will in the age of COVID. That's the subject of today's ACTEC Trust and Estate Talk.
Welcome to ACTEC Trust and Estate Talk from the American College of Trust and Estate Counsel, a professional society of peer-elected trust and estate lawyers in the United States and around the globe. This series offers professionals best practice advice, insights, and commentary on subjects that affect our profession and clients. And now, our ACTEC Fellow host with today's topic.
This is Susan Snyder, ACTEC Fellow from Chicago. Electronic wills are new everywhere, but are especially new in Florida. To offer us an education on electronic wills, we are joined today by ACTEC Fellows Bill Boyes of Palm Beach Gardens, Florida, and Tom Carr of Miami. Welcome, Bill and Tom.
Hello, this is Tom Carr, and thank you for that introduction. And welcome to Bill Boyes and Tom Carr's podcast on proving a will in the age of COVID. Well, I certainly hope it's not the age of COVID. I hope it's the short time of COVID, but it does seem like it has been an age. Or I think a better sort of title for this one is, what's all this about electronic wills? Well, when Bill and I agreed to do this, we sent out a survey to some of our ACTEC fellows on the Fiduciary Litigation Committee, actually to all of them, seeking their experiences so that we could punctuate this presentation with things that they've experienced with regard to electronic wills, because, of course, electronic wills are becoming something of an item, not just in Florida, but in other locations. And we got back nothing. So I think this is a bit more cutting edge than Bill and I thought it would be, and we hope to give you today our views on the law as it exists now and some examples of how it might be applied. And with that, Bill is going to start us off here today with some background and observations on electronic will statutes and the Uniform Act. Then we're going to talk specifically, and I'll cover that, about the Florida statute. And then Bill and I are going to come back together with hopefully some fun questions about how that statute might work or not work. Bill, take it away.
Thanks very much, Tom. I appreciate it and love the introduction, by the way, and all the huzzahs that you've given me. Electronic Wills Act. What is that? Well, basically, it's something that would affect otherwise the statutory requirements of what we historically known as what's required to have a will disposing of a person's property after their death. So historically speaking, the electronic will statute, prior to its enactment, every will had to be in writing, signed at the end by the testator or another person at the testator's presence, and at the express direction of the testator. The Electronic Wills Act is a template for states to approve the validity of property executed electronic wills within the restrictions as decreed by the particular statute involved, as that may vary state to state. And of course, this is excluding any type of holographic will enablement as the states may permit under their particular statutes. Prior to any electronic will statute, the statutes of the various states and the case law that had been in existence with the intent. Let's keep in mind the reason for all of this. The intent is to safeguard against fraud, forgery, undue influence in connection with the establishment of the validity of the will. Under the Uniform Act, states are enabled to determine how many witnesses are required on the electronic document and whether or not a notary is required and whether or not actual physical presence is mandated in the presence of the testator for either witnesses or the notary, or whether or not a remote presence of the witnesses or the notary is permitted. Historically, this remote witnessing, remote notarization is something that's new to us. Take it back 10 years, we didn't have this. What we had was centuries worth of case law and statutes that enabled one to determine whether or not a document purporting to be a will was in fact the true and valid last will and testament. Various states have enacted their own statutes. Remote witnessing is allowed in Florida, Nevada, and Indiana. Arizona says no to remote witnessing. What about per the Uniform Act, a qualified custodian. Well, certain of the states don't speak to this at all, whereas a qualified custodian in Florida, Arizona, Indiana, and Nevada are mandated. The Uniform Act has something that certain of the states do not, which is the harmless error rule. The Uniform Act contains the harmless error rule, which provides for a safe harbor in the event that the electronic will is not executed in strict compliance with the statutory mandates, and the witnessing requirements may be deemed so as to comply if it is established by, here's the test, clear and convincing evidence that the intended electronic document is A, the decedent's true will, and that B, or that it's a revocation or addition or revival of a prior will, even not an electronic will. Boy, we're going to have some fun with that on down the road. So I'm just going to capsulize some of the statutes of the various states and what they mandate. Utah says that there has to be two witnesses, that they can be remote. There has to be a notary, but there is a harmless error rule under the laws of Utah, but no necessitated qualified custodian. North Dakota is exactly the same way. Nevada permits remote witnessing and notaries. There is no harmless error statute, but it does mandate a qualified custodian. Remote witnessing is permitted in Arizona, but there is no standard for the notaries. Harmless error is permitted with the extrinsic evidence requirement. Under Indiana, no harmless error, no qualified custodian. Florida permits remote witnessing and notaries. They're okay. The notary. So your testator, your witnesses, your notary could all be in four different locations. Interesting. So what we have here also is under the laws of the state of New York and Governor Andrew Cuomo, he enacted in April of 2020, an executive order which permitted remote execution of wills. There is one reported case on that. It's in re the matter of Ryan. It's a surrogate's court out of Broome County. And it's the only cited authority that we have interpreting some type of electronic will statute. The decedent was actually in the hospital at the time of the execution, but he had communicated his wishes by telephone to his attorney previously. So the attorney prepares the will, and at the time of the signing, the hospital social worker brings the original will to the decedent in a sealed envelope and acts as a videographer with her cell phone. At the time, the attorney and the witnesses were in the attorney's office. The testator was in the hospital. And the court found that with those fact patterns and the execution and after the notary transmitted electronically the execution video of the document, the decedent died. And the court permitted it as a self-proved will in accordance with the governor's executive order. There's one other case that I want to bring to your attention very quickly, which is something that permits this extrinsic evidence to establish a decedent's true will when there is no compliance with the will statute of the state. And that is a Michigan case decided in 2018. It's in re Estate of Horton, Horton, reported at 625 Northwest 2nd, 207. And under this case, it was a young man who decided to take his life. He left a handwritten note that was not signed by him, but it was in his handwriting. And it says, check my cell phone. And there's an app there. And it says how I want to dispose of my property. Well, this guy was under a conservatorship at the time, and his ad litem offered that signed document, that that handwritten document, not signed, and the electronic app as the decedent's true last will and testament. Michigan has a statute called the Estates and Protected Individuals Code, otherwise known as ACTEC, and it requires that there must be liberally construed and applied to promote its underlying purposes, including to discover and make effective a decedent's intent on the distribution of his property after death. And after a trial, the trial court found that it comported with that ACTEC statute, and it was established by clear and convincing evidence, and it enabled the decedent's mother to be eliminated as a beneficiary and instead have his assets pass as he wished to his siblings. It's a very interesting that's a safe harbor on steroids, Tom.
So let's go talk about the Florida law and the Florida statute, because that, of course, is what Bill and I are most familiar with, being Florida lawyers. And it's very interesting to know a little bit about the history of that statute, because it's very telling about, I think, what's going to happen with statutes going forward, or the passage of them. Prior to COVID, the real property and probate trust law section of the Florida Bar, that's us pointy-headed individuals that go to these meetings 4 times a year and talk about the statutes and debate them, were very much opposed to these statutes. We didn't want electronic wills. We didn't want remote witnessing. There were dark mutterings of fraud that would follow, and the abuse of elderly. Oh my God, this is not the way we want to do things. We want to do things the way we've done them for, as Bill said, hundreds of years. But these Silicon Valley folks came out of nowhere and said, wait a second, we're going to provide you with a method for executing your wills that will get rid of fraud, that will get rid of abuse, because everything will be recorded, everything will be seen, everything will be on the record. Maybe, maybe not. But they did make one point, which I think was very valid, which is it is also making this service a lot more accessible to individuals, because if you can do remote witnessing and remote execution, you don't have to go to some lawyer's office to get that done. And so they did have a point. And with that point, they were able to move the Florida legislature to view this very positively, despite the opposition that came from the lawyers that have to deal with this day in and day out. And so there was a succession of things that happened over the years. In 2017, the bill didn't pass because the governor vetoed it. In 2018, it didn't pass because there was a fight between the House and the Senate in Florida. That's a whole other story, which is funny. And then in 2019, it finally passes because those kids from Silicon Valley, they're smart. And what they did was they neutered the whole argument that came out of the probate lawyers by combining the notarization, the remote notarization with the remote execution of wills. And it made it impossible for the section of the Florida Bar to oppose it in any considered way, because we are the real property and probate section. And the real estate lawyers love remote notarization because, of course, it's much more efficient to notarize things thousands of miles apart from each other than everybody having to get to a closing. And, the probate lawyers, be damned. They just had to sort of sit back and let this happen. But of course, they provided their input on the statute. And some would say that input was not very helpful. And let's talk about that a little bit. But before we do that, let's just make one more point about this, and that's this, that it was very interesting to me, anyway, that after all of the hoopla from the probate lawyers, we like to call them the death lawyers, about why we shouldn't do this and why we should do it like we've always done it for the past 500 or 600 or 700 years, is suddenly facing COVID. And when COVID hit, a lot of those people who were so against it were suddenly so for it, or at least for some aspects of it. And so it's sort of an interesting, I think, commentary on how principle can be completely overwhelmed by the public health emergency in the blink of an eye. And so I think that will portend for more of these statutes passing. But let's talk a little bit about the Florida statute, because now we're left with this Florida statute, which is sort of interesting because it has 2 general aspects to it. One is a chapter of the probate code, and one is a chapter of the notarization code. In other words, you've got to toggle back and forth between two sets of statutes in order to understand how and whether you can actually do this electronic will thing in Florida. And at first it allows, of course, an electronic signature. Oh, okay, no big deal. We all know we've probably all done electronic signatures already. And then what it does, it says, now when it comes to remote witnessing, you must do it in accordance with Chapter 117, which is, you got to go over here to the notarization statute. And there what you find is that now the law makes the notaries the supervisors of the executions of electronic wills. It sets forth specific rules that those people must follow, those notaries, those people that you go to, who ask you for your license and make sure that, you look like the person on the those people are now going to be the supervisors. I wonder what this might portend for the future for people who handle that in terms of them being able to put on their resume how good they are at this. But in any event, those people are now supervising the execution of the document, and there are prerequisites for them to do so. And there are prerequisites for actually using this process. And one of the things that you have to do in order to be able to prove up one of these documents is the document itself has to be held by a custodian, a qualified custodian at all times. And there's a bunch of things about what a qualified custodian has to be under the law. But one of the things it says that a qualified custodian has to have is it has to have a, quote, secure system, which means it has to have a system that can't be monkeyed with so that whatever goes in comes out the way it went in. And I submit that's going to be a very interesting topic for litigation in the future as well. But of course, the secured system and the qualified custodian is the money maker. It is the thing that those people in the cool suits out in California came up with because it's a great idea to make money. You have a secure system, you have a qualified custodian, you've got to pay them in order to lodge your document there. And that's, as I said, where the money is. So what protects the citizens of Florida here? What is it that protects them? Well, I'll tell you, if you take a look at that statute, the legislature of Florida certainly was looking after the citizens here by requiring that all of these qualified custodians have, and write this down, $250,000 bond that they post for damages, and that they have a $250,000 insurance policy. And if you don't know it, I'm being sarcastic. I don't know many estates that add up to $500,000. There just aren't that many that these people in my area deal with. So I'm not sure that the citizens of Florida, let's say, know exactly what they got. So in any event, we have this new statute, and when you look at it, it has some interesting things about it. One of the things it does is it requires the notary, as I said, to be the supervisor, and they have to ask specific questions of the person who's signing this will remotely. And the questions are listed in the statute, and they have to go through these questions. And if the questions aren't answered correctly, you would think, that means you can't have an electronic. Well, not really. They can answer the questions wrong. For example, one of the questions is, are you under the influence of any drug or alcohol today? Or do you have any physical or mental condition or long-term disability? Or do you require assistance with your daily care? If they say no to that, you would think, you can't do it. Not necessarily. Not necessarily, because the statute says even when they answer those questions wrong, unlike in the Monty Python scenario, they don't get thrown off the bridge. It just means that you gather that evidence to determine validity at another time. And then the statute goes on to say that the notary has to give a notice to the person signing the electronic will that tells them that if they're a vulnerable adult pursuant to some long definition in the Florida statute, I don't think these people are going to their will executions with statutes, but they're being given a notice that says if you're a vulnerable adult as defined in the statute, this is not a valid document. So that I'm not sure will be helpful or not. And then they have to ask them 5 more questions about who's in the room, who helped them, how did they get there, all things that are fodder for a will contest. So that brings us then to current times, which is, Bill, let's start off by giving people a little bit of a taste of what it's like to deal with this statute. I mean, after all, we now have this statute. What could possibly go wrong when you employ it?
Well, let's start with the video requirement. we all know that the witnesses to the will be probably in one location and the principal in another. So we need to have everything videoed.
So what could go wrong there? I mean, all these guys in Silicon Valley said, hey, look, there it's going to be. It's all going to be on tape. We'll stamp out fraud. We'll stamp out lack of capacity. We'll stamp out undue influence because you can just look at the video and see what happened, right?
Yeah, well, just it raises a few questions, Tom, such as, was the video feed continuous? If not, why not? What was going on during the breaks? Did the videographer record that? Why not? What about the actual image of the person that's signing the will? Was his pulse bulging on the side of his neck? What about the responses? What about the pupillary dilation? I can see that there being a necessity for having a director of a video execution of a last will and testament because it makes for good theater.
What about this list of questions, though? Are they going to help us ferret out, when there's been undue influence or when there's been some lack of capacity issue? What do you think?
Geez, I don't know. But, let me think about that. Listen, Sonny, am I a vulnerable adult? I don't know. I don't remember.
Well, I can see your point. I mean, you have the first three questions, and, it's interesting when you go through those questions, they don't seem to sound like, the mature people that I think practitioners deal with that are signing these documents, because I think they all suffer, myself included, being of mature age, that you might have a deficit or two that might cause you to answer that question, let's say in a way that was not favorable in the statute. But let's move on. You sound like a pretty cynical guy to me. I mean, Bill, you're coming up with all the negatives here. I mean, to me, isn't this just a great thing? Now you can wake up in the morning, make yourself a cup of coffee, you and your spouse sit down to video and witness your friend's will execution. I mean, isn't that a lot better than having to be squeezed into a small room and inhaling everybody's molecules?
Listen, sounds like potential fodder for a will contest, because of all of the things that could possibly go wrong in the 50 years I've been practicing law, I have never videoed an execution of a testamentary document. I would rather have the court rely upon my expert testimony that, the person was good. And let's just leave it at that, Tom.
Well, with that, I think our time has run out or run over, and we'll have to end our presentation here. But let's end it with the thought that there are many more questions to ask about the application of this statute and much more for us to see. So thanks for listening.
And thank you, Tom and Bill, and thank you this education on the new phenomenon of the electronic will and its definite pitfalls.
Thank you for listening to this episode of ACTEC Trust and Estate Talk, the podcast series about wealth planning matters from the American College of Trust and Estate Counsel. To find an ACTEC lawyer near you, visit actec.org. Please subscribe to this series and leave us a rating or a review. Follow us on Facebook and Twitter at ACTEC Talk.